Hello, I'm David Chooljian of the VA Loma Linda Healthcare System and Loma Linda University, perhaps obscured by my recorded picture there. And it's my privilege to be talking with you as a pulmonary and critical care physician, as a member of the bar in California, and as an ethicist about when they want everything done, responding to inappropriate therapeutic requests in the critical care setting. So what are we trying to achieve today? Well, first, we want to recognize the importance of patient and surrogate decision maker derived goals in coming up with determinations about what's medically appropriate or inappropriate. I do want to make sure that we promote some awareness of legal and regulatory elements in responding to requests for potentially inappropriate care. And lastly, I want to make us aware of some best practices in how to respond, the actual techniques of responding to some of those requests. So some disclosures. I don't have any financial conflicts of interest that would be pertinent here. I am the immediate past chair of the Ethics and Conflict of Interest Committee for ATS, and we'll be talking about a policy statement that the committee was asked to review as part of its development process. And as a member of the bar, I get to give you this disclaimer, is that I'm presenting legal information in this talk, but it's for general educational purposes. In other words, I am not your attorney. And so now, with that out of the way, let's look at how we're going to achieve this. We will talk about the F word in ethics, futility, look at how it might have developed and whether it's as unilateral as we might think. We'll look at some pertinent legal standards relating kind of modern day concepts of futility. And a professional standard regarding it as well. And then again, we'll use some materials to actually show an example of a best practice for responding. So this idea of futility seems like it's diametrically opposed to the magical mythical, oh, they want everything done. And this is something that keeps coming up again and again in critical care, including the critical care of this young lady. I'm just taking a moment for you to look at her. Some of you might actually recall the case, or of course, just from looking at her would know what she had been seeking care for. This was Jahi McClain. I say was, but you know, the question mark about the date of death there. Jahi had presented to what is now Oakland Children's for a surgery to address obstructive sleep apnea. Unfortunately, in the post-operative setting, in the PACU, she had a code called for bradycardia followed by arrest. Multiple hours of work done, very unstable during that time, did have return of spontaneous circulation, but a lot of ischemic encephalopathy. And so ultimately she was declared dead according to neurological criteria by multiple physicians. Now the multiple physicians became involved because after the declaration of death, the hospital had informed Jahi's family that they intended to withdraw life support from this now deceased patient. The family contacted a member of the bar, had a cease and desist letter issued, and they sought relief in Alameda County Superior Court. Ultimately, the court sought out additional evidence, and the process went on for a while, late 2013 or early 2014. Ultimately, a deal was reached whereby Jahi was released to her family's custody. They flew her to New Jersey, where the possibility of objecting to the declaration of death by neurological criteria was and is available. And she actually stayed there in an apartment under New Jersey Medicaid for some time, receiving extensive therapies, including ventilatory support. Ultimately, in the setting of some hepatic dysfunction, she actually had hemorrhage, which caused another cardiac arrest, but all the way in June of 2018, and she did not have return of circulation from that. And the headlines at the time maybe made those of us in ethics wince a little bit because they said that she had died at that point. Now, very early on in the case, we see this seeming dichotomy. Okay, you have the hospital saying, oh, it's futile to be doing this to a dead body. And you have the family a few weeks later saying, well, we want to do everything possible for her. So why was the hospital so keen to declare something futile? Well, let's look at the concept. Now, it's a common concept, and especially in critical care, up to a third of us on any given day believe that we do have a patient receiving futile care in our ICU. That feeling, by the way, in survey data is associated with a desire to leave the field, so it causes us some distress. And let me see if I can persuade you that this idea that we've come up with is in part a backlash against the rise of patient autonomy and therefore deference to patients' wishes. You look in the late 1970s, you have the Belmont report highlighting the importance of informed consent for therapies and research, perhaps. And not long thereafter, something that is still with us to this day, the idea of the Press-Ganey assessment of patient satisfaction, adapted from businesses looking at customer satisfaction. And are our patients really customers? It's probably a talk for another day. Now, in response to this, shortly thereafter, you see this piece in 1986 in the New England Journal that has a really delightful phrase, which is talking about this danger of an unbalanced approach to autonomy. Maybe the pendulum has swung too far towards the patient side of things in their power dynamic. And lo and behold, this idea comes out of, well, even if the patient actually has decision-making capacity and is making an informed decision, if they want something that from the medical perspective doesn't have a modicum of potential benefit, then we're not obligated to provide it to them. So that's interesting in terms of it's the physicians making a determination. Now, the ethics community, right, has really looked at how you would define futility, because that seems like it's a powerful concept. And again, in the interest of full disclosure, as a former fellow and a trainee of the VA National Center for Ethics in Healthcare, I do want to put out there a perspective of that center. And here it is regarding defining futility. It's difficult to do. Other components of the ethics literature might be more helpful. We have this idea from a prominent ethics text that determining medical futility is really seated with the physician. And this idea that the physician says, well, there won't be any benefit to the patient. But how do you go about making that determination? Well, in this literature, there's the idea that it would be a physiologic determination, where it's just impossible physiologically for the desired response to be achieved by the intervention. So do you do now a therapeutic phlebotomy in sepsis to decrease the amount of circulating cytokines? I don't think that's going to resolve the sepsis. Things are rarely that cut and dry, and so more realistically, we talk about this idea of a probabilistic definition of futility, where there's just a vanishingly low likelihood of providing a desired benefit. But you look at that last word and you say, well, who defines the benefit here? Benefit is defined relative to a goal for medical therapy, and that comes from the patient. So even though this may have arisen as a unilateral kind of approach to a medical situation, the patient's the one who sets the goals. And when you look at that, right, patients often will define their goal for receiving medical therapy in a more qualitative way, especially when it comes to life-sustaining therapies, rather than quantitative. And with that, right, that idea of quality of life, well, the patient, right, is the one who can really define an acceptable quality of life to them. Now, if they don't have the capacity to do that, then their ethically appropriate surrogate decision maker is who we would engage to do that. And so you see where even this idea of futility, again, maybe arose as a unilateral empowerment of physicians, is actually a shared decision. And so you have a benefit that comes from the patient or their surrogate. The physician then is in a role where they are giving a probability that that benefit would actually accrue. If there's any disagreement or maybe lack of clarity, then of course the respect for autonomy would tend to dictate a deference to the patient's wishes. There are exceptions to that. There's the aforementioned idea of physiologic futility. But then also there's this idea that in some situations, resource allocation being one that's been on everybody's mind in pandemic times, that there's a quantitative futility cutoff that we look for. Pre-pandemic, that was and is, I suppose, best exemplified in organ transplant. If we think that people don't have a high enough likelihood of surviving the transplant process, then even though they make an informed decision to seek out transplant, we do not defer to those wishes. Now, you put all that together and you say, well, okay, this idea of unilateral invocation of futility is increasingly rare. And instead, what's evolved is this more nuanced idea of evaluating whether or not something is medically appropriate. For further looks at this, by the way, for a good bit later in the New England Journal, you had this piece and some delightful letters about the rise and fall of futility, and I'd encourage you to go to that. Now, we've talked about what ethics has had to say about this and somewhat now antiquated idea of futility and the evolution into medical appropriateness. Let's look at what the law has had to say, and we'll look at two kinds of legal standards. We'll look at state legislation, so statutory law, and state common law, so judicial decisions. So first, Looking at how the law in this area has developed, a prominent law is this model law from the early 90s by the Uniform Law Commissioners. They give a real pertinent element here about what healthcare providers are obligated to do. And what they note is that their obligation does not exist if medically ineffective healthcare, right, is what is being instructed by the patient. So this was a model law, and states can choose to adopt this in various ways, modify it, etc. In California, right, it was adopted as the Healthcare Decisions Act, and they didn't define what medically ineffective healthcare meant in California. Apparently, the legislature was too busy regulating things like bovine flatulence and plastic straws. But they did give us a hint here in the part of the code where the law was implemented. There's a lot of text kind of setting tone and intent. But if you focus on these elements, it really comes down to two things. One is that you're going to be making these evaluations on life-sustaining or life-saving therapies. They're designed to extend life beyond its natural limits. And then also there's this focus on whether or not something will provide anything medically necessary or beneficial. And that scrutiny is really heightened if it's a situation where there might be unnecessary pain, suffering, or loss of dignity. Now, the significance of those elements in the law is that the state code actually goes on to say it's one of the grounds under which physicians could decline a patient's healthcare instruction. And so if we look at those bases, one is conscience, if there's a violation of a provider's conscience. One is now, as we've said, if there's a instruction to provide medically ineffective healthcare. And lastly, there's the possibility that the instruction of the patient would lead to a violation of the standard of care. So any one of those could be a reason that you would decline a request from a patient. Now, how you go about that is also codified in the probate code. You have to inform the patient or their surrogate that you intend not to provide the therapy that they're requesting. You then have to assist them in a transfer process, or at least evaluation for a transfer process, if they so desire. And during that time, and this gets kind of interesting in critical care, you have to provide continuing care. Now, note it doesn't say escalating, but you have to provide continuing care until the transfer either can be accomplished or it becomes clear the transfer isn't possible. Now, and for many years, actually, that law in California really hadn't been validated or maybe tested, is a better way to think about it, by a judicial decision. And so let's look at this one in 2018. The citation here tells you that it went up to an appellate court, and it deals with this unfortunate lady. Ms. Alexander had come to actually Loma Linda in 2012, had abdominal pain, was found to have widespread pancreatic cancer. She sought care in a number of Southern California institutions and received oncologic therapies. Now, despite that, she deteriorated and ultimately was admitted to a skilled facility in early 2013. And at the time of admission, she had a pulse completed, which is very common and still is common, as a condition of her admission to the skilled facility, and also had an advance directive that was noted to have been completed. The advance directive named her son as her surrogate decision maker if she lost her capacity, and instructed that she receive all life-sustaining and life-saving therapies that were available to prolong her life. She continued to deteriorate at the skilled facility, even though artificial enteral nutrition was started. And when her son was told that she would die in short order, he refused to change the plan for life-sustaining therapies, and so she was sent to an acute facility, Scripps, in early 2013. The admission notes at Scripps note that the son wanted everything done, so there's our magic language for his mother to save or prolong her life. Well, the hospitalist who admitted the patient notes that her overall prognosis is dismal, presumably regarding the possibility of saving or extending her life. And so states that the overall goal is and should be palliation, and initiates therapy for that. And he involves oncology, and oncology actually talks with the son and again says that death is imminent, there's no further therapies that could be provided safely. And palliative care is involved and notes the same thing, while also stating that the son is very difficult, which of course is often shorthand for doesn't agree with us. They actually convene, as a result, an appropriate care committee in February 2013. The committee, right, does meet, and they discuss their decision with the son, and their decision is that no, life support therapy should not be continued or escalated. The son disagrees, and so an ethics consultation is requested, and transfer process is begun. Now, ultimately, the very facility that had sent Ms. Alexander 2 scripts accepted her back in transfer, but before that transfer could be completed, and in the setting of these palliative measures that had been initiated, she arrested, a DNR order had been unilaterally entered, and so resuscitation was not attempted, and her son filed suit. Now, one of the causes of action, so the basis of the suit, it was right, that the hospital had refused a request for a therapy, in this case, life-sustaining therapy, by the patient through her advance directive and by her surrogate decision maker. The holding, right, so the judgment of the court on this particular legal issue, right, just cited right, the aforementioned language of the Healthcare Decisions Act, saying there was not any significant benefit to those therapies, and therefore there was no requirement they be provided. The court had noted that the process had been followed, right? That the surrogate had been informed, that there had been the opportunity to seek transfer, that supportive care had been given, etc. And so it really upholds this idea of a lack of obligation to provide a therapy that's not beneficial just because a patient or family is requesting it, and it doesn't create that obligation. Now, that's the law, and so let's see what our profession in pulmonary critical care has come up with. Well, there's this official multi-society statement in 2015 responding to requests for potentially inappropriate treatment. So note that futility is actually not a title element here. And so they actually have a very nicely outlined process that can be followed. So we'll take a look at some key elements of that. Okay? So key elements we're going to include are prevention strategies. How do you head off these requests before they're even made? How do you use clear and consistent terminology, both with patients and families and between providers, right? Because there's a lot of confusion or lack of precision, maybe, in inter-provider discussions about this. And what processes can you engage in to resolve conflicts about these requests? And lastly, how do you respond to time pressure requests? So looking at each of these in turn, when you look at prevention, the statement really breaks it down to things that systems can do and things that clinicians can do. So on the system level, what the system should encourage is that you actually set aside time to have family meetings. Hopefully the system values that time enough to protect providers' time to do that and set up a structure for them. Now, part of structure, you might argue, is actually having a place, a physical place to have these meetings, which in many institutions is a real problem. Now, on the clinician side, again, clinicians should not only engage in these meetings, but have a plan for them, and especially given the complexity of critical care, and multiple organ systems are often going awry, you'll have consultants involved. And what you really need to do is have a consensus before the meeting, right, about what the overall message should be and what the points that are raised in the meeting should be and the goal of a meeting. And often in our busy practices, it's difficult to do that before the meeting, but it is a best practice. Now, if you can engage in that sort of planning, you also, at the beginning of a case, hopefully can engage in planning with a surrogate for a critically ill patient who can't make their own decisions. And you can actually ask the surrogate, how do you want to be involved? How much detail do you want? Are you more detail? Are you more big picture? So we really rarely ask about how surrogates would like to be communicated with and how involved they would like to be, but it's good to do that up front. Now, once you've engaged in those preventive practices, the communication that you engage in, right, should use precise and accurate terms. So let's look at futility, right? The statement does say that futility does exist, but they've limited to the aforementioned idea of a physiologic futility. So you simply can't accomplish the intended physiologic goal. Gives an example of a patient who is already entering rigor mortis, and you have a family asking for ongoing or initiation of resuscitation attempts. Right? So physiologically impossible. As we had said before, that's pretty rare, but there is a branch point here where it's physiologically futile, and so we can unilaterally declare that. Now, more realistically, we may get into a situation where something isn't futile, but it may be either legally proscribed or legally discretionary. So looking at the difference between those, if something's proscribed, it's legally prohibited. The treatment might work, but we're legally barred from doing it. And a great example is when families ask us to kind of bypass the organ donation process or organ procurement process to get their loved one an organ that they wouldn't otherwise have access to. As far as that situation, again, should be fairly rare. Something that is a little less rare is where a treatment is legally discretionary. So again, it may work, but the law, right, actually allows use limitations based on physician judgment. And so that's where that medically ineffective treatment idea comes in, as we had examined earlier. So again, next branch point, it's still pretty unilateral at this point in terms of the decision-making process. Then we get into the potentially inappropriate therapy, which I think is the vast majority of the time what we're actually dealing with. This is where the therapy at least has a chance, right, of accomplishing what the benefit is that's been determined by the patient or the surrogate as their goal, but it may not be justified based on competing considerations, everything from a fair allocation of resources to the harmful effects of the therapy itself, and so violating our desire to engage in non-maleficence. Now, the fact that we say, oh, there's some chance and may not be justified tells you that you really need to review these requests and that there may be conflicts about them. And so we'll look at how those may be resolved. And so you see the next step here is to say, okay, is it potentially inappropriate? And if so, and there's any disagreement, we have to engage in a process to resolve those. Now, how do we do that? And key elements here, and again, some of them should seem familiar from our review of the law before. You get your expert consultants involved, and hopefully that will include your friendly neighborhood ethics consultant when it's appropriate to do so. You want them involved fairly early on if possible, and if you can see this coming, really an ounce of prevention is worth that pound of cure. You have to give notice, and we as providers, we don't like these difficult discussions any more than the next person, but you have to give notice to the surrogate saying, hey, we're going to go through this process, we recognize there's a conflict, and we give them the opportunity to be involved as appropriate. Now, getting that second opinion from somebody not on the primary team hopefully should be a common practice in any kind of sticky situation, but you really want to embed that in any process here. You hopefully have at your disposal an interdisciplinary committee at the hospital where you're practicing critical care who can look at this and involve all parties, indeed including the patient or surrogate more likely. If the determination of this review process is that the clinician's right in not offering or not continuing to offer the therapy, then you have to encourage or at least advise the surrogate to seek review elsewhere or seek transfer. If the determination is that the patient or surrogate is correct, you can provide the therapy. If it comes down to a matter of conscience, right, for the provider, then they have to seek out another provider to do it. Now, that process, of course, takes time, usually not as much time as we think it'll take, but it does take time. And so if you get a situation like this one, right, where the patient's already on maxed out pressors, the family's asking for ECMO, but the team thinks that it would be inappropriate to give that, and then the statement does offer some key steps in a time pressure situation. And so first, you really have to go over the situation and what the decision is and its basis, right, again, with the surrogate. So that notice, right, really can't be circumvented as a requirement. You do want to bring in other clinicians, but the other key element here, and this is one that unfortunately does get violated, is if you're really sure, right, that it's inappropriate, then you don't offer it even in a temporary plan. And I think that's where a lot of clinicians get stuck, where they say, oh, well, we'll just start it and then we'll deal with this request. And you say, no, if you're really sure, then you don't get it started in the first place. And so that's outlined as a step here. Now, that's how our profession, right, says you should be dealing with these. But there are some best practices in the communication that you engage in when you're responding to these requests. So let's look at three of those. First, acknowledging the emotions behind the request. Second, not letting the therapies be the goal defined by the patient or surrogate. And then lastly, expression of a goal according to activities. So with that, looking at the first one, this idea of acknowledging emotions, right? If those emotions aren't acknowledged or aren't felt to be acknowledged on the part of the surrogate or patient, you're really starting out kind of behind in terms of developing a rapport. Now, you do that by empathizing, but you always want to bring it back into reality. And so the key is using I wish language, right? Instead of, oh, I'm sorry. Oh, I feel that this is a rough situation for you. Oh, I hope that we can do something. You just keep consistent. In these examples, what you see is a lot of the proper technique here is really conditioned on starting out with that I wish and then transitioning into another statement. Right? So I wish it were possible that we could do something, but since we can't, we should focus on these things. Right? So let's look actually at an example here from a series by Vital Talk that the VA had commissioned as part of engaging in goals of care conversations.
Is there anything more you can do?
Can you tell me a bit more about what you're thinking?
I'm an optimist. I want to clutch at every straw there is. If we haven't done everything, I just got fight in me. Let's do the next thing.
You know, I want to acknowledge the fact that you've always been a fighter, and that's a quality in you I've really admired. You know, I know it's really hard for you to hear that there may not be another chemo or treatment for your cancer. I wish there were, but I'm just afraid that there's nothing out there that's not going to do you more harm than good.
If this is going to get me in the end, and there are no other options, let's get comfortable.
So we see in that example the I wish but. And so the I wish does acknowledge the emotions behind that request, and then there's the reframing. And now, another best practice here. We not infrequently encounter this idea of the goal is to receive therapies. The medical goal is to receive therapies. And sometimes that's explicit. Oh, his goal is just to get every treatment there is. Sometimes it's a little bit more implicit. Oh, they're a fighter, right, as we heard in that last example. Now, this can work in reverse, too, in terms of therapeutic avoidance, right? Oh, just doesn't want chest compressions or doesn't want a tube in the throat, which also doesn't get to the why, right? So you really want to look at this as a sign or manifestation, right, of the idea that therapy is somehow reflective of value, right, of a patient. And in that situation, which is especially true in a lot of disenfranchised populations, you got to emphasize that there's not abandonment occurring just because that particular therapy is going to be withheld or withdrawn, right? And on that note, I always encourage people in cases like this, you don't say, oh, we're withdrawing care. You say, we're withdrawing life support. You're still going to care for the patient, just with a different goal in mind. And so a key strategy here then becomes converting that seemingly dispositive statement, oh, I just want everything done, she wants everything done for her. Okay, well, why, right? So what is she fighting for, right, if it's expressed that way? Now, one thing that can help, right, is if you try to express that goal or elicit that goal in terms of activities that are meaningful to the patient. Amongst other reasons to do this, it's objective, right? We can be consistent, and by we, it includes not only the providers, but the patient, their family, in terms of whether or not they can engage in that activity. And hopefully, right, the likelihood of engaging in a particular activity is a little bit more concrete than something more nebulous, like, oh, being comfortable. So the activities themselves can also give you a little bit more insight into the patient and therefore maybe their values and what's important to them. And so there's some examples here from real cases. I've just had a case very similar to the second example just a little while ago in the ICU. So if you can express things in terms of activities when it comes to articulating a goal, that's really valuable for everybody involved in a case like this. So with that, what we've covered is the idea that this futile concept really has evolved right into evaluating things as more potentially inappropriate and with a real medical spin on that idea. There are professional and ethical standards for how to respond. Note that you're not obligated to provide the therapy, but according to those standards, you have to have a way of resolving disputes regarding these requests, and you have to inform the surrogate or the patient that process is ongoing. According to the law, right, again, you don't have an obligation under the law to provide these therapies, right? But again, you have to inform the patient or the surrogate, and you have to offer the opportunity to seek transfer if they disagree with the determination. And the techniques that you can and should engage in such cases: acknowledge the emotions, but reframe using that I wish and then language. You really want to prevent goals being expressed in terms of the therapies themselves. So don't make therapy or don't allow therapy to be the goal. And in eliciting goals, make sure that you're asking about meaningful activities, which really helps, I think, everyone involved. And so there are quite a lot of references out there. Here's some key ones that I've picked, including the aforementioned piece about futility in the New England Journal. And both in the upcoming session after this recording and separately, I'll be happy to entertain questions, comments, concerns, hopes, dreams, wishes, or desires regarding this topic.